Hello, everyone. Today you've got two talks for the price of one. We're doing two quite separate talks on recent developments in local standards and jurisdiction. We've got Andrew Arentsen who's going to speak first. He's going to be speaking with regards to an update on what courts require in relation to local standards evidence. Andrew won't mind me saying this, he was junior counsel in Lougheed and on the beach, which is obviously, as most of you all know, the leading case still on this. So we're very fortunate today that he can offer some insight into what's required. I'm going to be talking about jurisdiction and developments on that. It's been quite a fast-moving field recently following Brexit and the judgment in Brownlee. And we're now starting to see an increasing number of applications and jurisdictional challenges. So I'm going to be talking about the developments in those. In terms of housekeeping, obviously, these are both huge topics. So we're going to move quite quickly. There are a lot of slides and those will come through to you automatically following this webinar together with a recording of the webinar. So if there's anything that you feel that we're moving a bit fast over, don't worry, you're going to have the slides. If there's any questions that occur, either during the talk or afterwards, for during the talk, there's a Q&A function. Please feel free to ask us questions in there and we'll answer questions on both talks at the end if there's time. And if any questions we don't get to, or if anyone has any particular queries, then our email addresses are both at the end of the talk on the final slide. Please feel free to get in touch. So without further ado, and not to waste any more time, I'm going to hand over to Andrew to get us started.
Thanks, Freddie. I'm going to try and take about 15-20 minutes in relation to the first part of the talk, because there's a lot more meat to what Freddie's going to deal with afterwards. So if I just start briefly in relation to Lougheed, as Freddie quite rightly says, a long time ago, I dealt with the trial at first instance, and then it went on to the Court of Appeal. And it's still now considered as the leading case in relation to local standards, although when the Court of Appeal determined that case, they were at pains to suggest that, in fact, there were no new rules that were being set, that, in fact, that this represented very much the existing law. Just briefly by way of background, because I know most people will probably be familiar with it anyway, that the facts of it were relatively common. That the claimant had purchased a holiday from On the Beach Holidays. There was an interesting side issue, which is that you go into the internet site as it then was. It might have changed now, and you select different parts of the package, so that flights, the transfers, the hotels, and the like. And the internet or the website was at pains to suggest that just because you had these things together, it didn't constitute a package. And there was a very interesting sort of sideline where the On the Beach called their expert IT people who designed that web process. The recorder was struggling with the idea that once you put in package holiday, one of the first things that came up was On the Beach, and that's obviously how it had been designed to work on the Google platform. But obviously they were saying, well, just because it comes up with holiday packages doesn't mean that what you then select is a package. That was dealt with by looking at cases of Titchell and QWERTY, which is within the handout, and the recorder quite correctly determined that just because you selected different components and that they were in that just because it wasn't called a package didn't change the fact that it was a package and the regulations applied. Then we got on to the more interesting issue, really, which is the liability for the hotel and the regulation 15.1 as it then was, because obviously the regulations have since changed, but essentially say the same thing. Now, what was interesting is how we got to where we were. What had initially happened before I got involved in the case is that the defendant had made an application to get expert evidence. That had been contested by the claimant, oddly, and successfully contested. So the defendant wasn't allowed expert evidence. Subsequently, counsel looked at it, I looked at it, thought, well, we really need some expert evidence in relation to standards that existed in Spain. And we made an application to do that, and the court came to the slightly bizarre decision that because it had said no to the defendant, it was also going to say no to the claimant, and therefore there was no expert evidence that was available at trial. So we pretty much pushed into the position where we had to proceed with the trial, even though, stepping back, in an ideal world, one would always have wanted to have that evidence. What was also interesting is we had expert evidence, and the expert evidence said this: there is no definitive system of cleaning Spanish hotels. There's no regulations which apply and designate how regularly things have to be done, or something of that sort. All we had is a situation where the Spanish code applied, which imposed a duty very much akin to the Occupiers Liability Act. In fact, there was even a reverse burden of proof, which meant that if an individual proved that there was a substance on the floor, the evidential burden was then on the occupier to demonstrate that it was there, notwithstanding the exercise by them of reasonable care. So you had a situation where the evidence that we had demonstrated that the situation was exactly the same in Spain as it was in the UK. And we all know that in terms of ordinary trials where you're looking at breach of Occupiers Liability Act and cases of that sort, you wouldn't have expert evidence. So that's where we were in the trial. The hotel manager gave evidence, and he was cross-examined on the basis that the standards that they would set in Spain were such that you wouldn't permit water to remain upon the floor, that there was that members of staff would pass regularly during the course of the day, and if they identified contaminant on the floor, they'd be obligated to use a cone to highlight it and then to clean it up. So the reality was that the evidence that the recorder had was that the systems that should be in place in Spain were identical to the systems that should be in place in the UK. And that was the basis of the finding at first instance, that essentially the standards were the same. It wasn't that the recorder was determining under English law. The recorder was saying that the standards that he was applying were Spanish standards, but he was able to infer those standards from the evidence which was available, including the hotel manager. That then went to the Court of Appeal. Mr. Justice, or Lord Justice Tomlinson, was quite clear in his judgment. He was pretty unimpressed with Ward and Tesco as a general statement of the law in any event, but that's probably beyond the scope of this talk. But what he said is this, that it is essential for a claimant to call evidence as to the local standards. It's not sufficient that that evidence comes in the form of a witness such as the hotel manager, although it does beg the question, if the hotel manager of that particular location can't give evidence as to what the required standards are, then it seems it's difficult to see who could. But of course, what the court was saying, the Court of Appeal was saying, is that the claimant has to, in order to get off the ground, has to call evidence as to the prevailing local standards. And if they don't, then they have some real difficulty. So that set out in the very clearest terms what a claimant needs to do. A couple of residual issues that are on the slide. The first is, who is your expert? We tend to think in terms of engineers as being the requisite experts, because we grew up with the cases such as with glass that was too thin, or building standards that were breached, or things of that sort. But of course, you also get issues of custom and practice in terms of managing hotels, in terms of cleanliness and things of that sort. So it may well be that the relevant expert isn't necessarily an engineer, but certainly you need somebody to give evidence as to what custom and practice and what standards would be expected to apply in the local area where the accident happened. And then obviously it flags up for defendants the issues that if claimants don't have that evidence beyond a certain stage, then applications for summary judgment are likely to be looked at fairly favourably by the court, because the reality is, absent evidence of that sort, a claimant simply cannot win. So it's certainly something to bear in mind in terms of case management. So that's where we were back in 2015, 2016, with what essentially seemed to be fairly definitive evidence as to what is needed and what the court should have regard to when looking at cases of this sort. Now, just moving things on a little bit, the first case is Brona Kerr and Thomas Cook. That was similar in this way. The claimant went on a holiday to Tunisia. She was attacked by a cat. And the evidence was that this particular four-star hotel in Tunisia had numerous cats that were described as feral in the gardens of the hotel. And this was a situation that evidence from TripAdvisor had demonstrated had been existed well before the claimant went on the holiday, and indeed well after. It was almost a selling point of this particular hotel that there were so many cats that were running around feral in the garden. So the claimant brought her claim on the basis that the defendant knew about it and ought to have done something to have prevented the injury that she sustained. The evidence was fairly limited before the trial judge. The defendant didn't call a great deal of evidence, and the judge at first instance determined that the defendant must have known of the presence of a large number of cats in and around the hotel. They carried out monthly health and safety audits, and it's simply impossible for them not to have been aware that there were so many cats in the gardens where obviously hotel guests would be present, would be relaxing by the pool and the like. But what then is interesting is Lord Justice Maguire dealt with the issue and said this: one is inclined to think that if a large number of stray cats are roaming around a hotel, that would give rise to some obligation on the part of hotel management to use reasonable care and skill to control them in an appropriate way. Stopping there, common sense would determine that the defendant knows about it and ought to have a responsibility in order to control it. But the big but is, unless the claimant establishes with evidence what the relevant local standards are, then the court is not able to infer a breach simply by whether by applying common sense or by applying the standards that exist in this country. So it's another clear example of a case where you might think, well, you really don't need local standards to say that it's potentially unsafe to have lots of stray cats running around in the way that it could, but the evidence the determination at trial was you can't succeed unless you have that evidence, which goes to the requisite standards in Tunisia in order for the claimant to demonstrate that there's been a breach. Now, Jennings said much the same thing. Jennings was slightly more complicated because there were three elements. What had happened in Jennings is that the claimant had booked a holiday all the way from Cardiff to Malaga. So that included flights from Cardiff to Malaga, and then I think there was a cruise that took place from Malaga, and the cruise went around the Mediterranean. And on the return, the claimant were docked at Malaga and was walking on the walkway from the port in Malaga when he slipped and fell as a result of water that had been walked through by staff who were unloading the boat. So there were three issues in that particular case. The first was the application of the Athens Convention, and that was determined against the claimant on the basis that the location of the fall wasn't part of the boat trip, and therefore, because it was the location was close to the port, and it wasn't part of directly the disembarking, then the Athens Convention didn't apply. Next question, well, did the regulations apply? And it was argued by the defendant that they didn't, because the crews had docked, and the same reasons that they argued that the Athens Convention didn't apply. But that wasn't correct, because of course the holiday included not only the cruise, but also the flights from Malaga to Cardiff. So the journey from the port of Malaga to the airport of Malaga, and obviously the flight then back to Cardiff, also fell within the body of the holiday, and therefore the regulations did apply. But, and again, it might come as no surprise, that the court first of all rejected the common law claim, which is set out at the top part of the slide, but more specifically for us, it dealt then with the claim under the package holiday regulations, and there was no evidence as to the standards that were to be expected in relation to Spain and the walkways that were present. And absent direct evidence of what standards ought to apply, the court dismissed it summarily. So it's another example of the court taking Lougheed, applying it in a pretty strict way in terms of the absence of evidence. Moving on briefly to Clay. Clay is a slightly different case, although it involved the package regulations. The claimant and his wife and parents were in adjacent rooms. The claimant and his wife had left their children in the one room, and they'd gone next door to have a drink with the in-laws. There was then this difficulty where the claimant went back to see the children. On returning, the door of the parents' room locked as a result of a defect. So the situation was that the claimant and his wife and his in-laws were in the room adjacent to the children, but they couldn't get out because the door was locked. There were two balconies which were adjacent to each other. And what the claimant did was to climb between the two balconies. He fell and sustained a catastrophic injury. Now, his claim was brought under the regulations on the basis of two defects. The first was that the balcony was defective because it wasn't able to take his weight. The second was that the door lock was defective because it locked when it shouldn't have, and that was the cause of obviously his need to climb over between the balconies. First instance, the judge found that the balcony was not defective under the regulations. It was not designed to take the weight of a person. It was a decorative balcony, or certainly the part at which the claimant stood upon was a decorative part of it, and therefore the balcony wasn't defective, and the claimant failed in relation to that allegation. But the claimant did satisfy the court that the lock was defective and that the lock breached local standards. So again, there was an analysis in that particular case of the local standards. There was evidence of the local standards, and the court determined that the lock was defective. But what the court at first instance found is that the decision of the claimant to then climb over the balconies was the cause of his fall. And that was a novus actus. Essentially, it was his decision that was taken. It wasn't a reasonable decision in the light of the door being locked. It was a warm evening. They could have stayed there for some time. They could have waited until somebody came. The decision that he took within a short period of time of the door locking to climb between the two balconies was unreasonable, and that was deemed to be the cause of the accident. Now, that went to the Court of Appeal, and by a majority of 2-1, the Court of Appeal agreed with the first instance judge in terms of the actions of the claimant breaking the chain of causation, and the risk of standing on the balcony was so great that it's something he simply shouldn't have done. So rather than it being a contributing negligence issue, it was the entire cause of the accident, and it was sufficient for the claim to be dismissed. There was a dissenting judgment, an interesting dissenting judgment from Lord Justice Moylan, who essentially determined that unless the claimant's conduct was so unforeseeable and so unreasonable, that therefore the locked door was a causative factor in the accident. And what Lord Justice Moylan determined in this particular case, it was certainly foreseeable that if somebody was trapped in their room, that they might use an alternative way to get out. So although the claimant might have been contributory negligent, certainly the defective lock was a contributory cause of the accident, and therefore not sufficient to defeat the claim. Now, I do know a leading counsel who was instructed in that case, and my understanding was that it was going to go to the Supreme Court, but I don't know whether it's a post-COVID thing. We're now several years later and we haven't had a Supreme Court decision, so it may be that that's been resolved. But it's certainly an interesting case insofar as local standards are concerned, and more importantly then, in terms of causation, looking at those standards. Now, Morris then is a county court judgment. What's interesting about Morris, it was a case where the claimant slipped on tiles and getting out of a shower. And the issue, there were two types of tiles. There was type 1 tile and there was a type 2 tile. The type 1 tile was designed to be used in areas that were not likely to become wet. The type 2 tile was designed to be used in areas that would become wet. So the type 2 tile had a higher slip resistance than the type 1 tile. You can see what's coming. The claimant got out of the shower onto a type 1 tile and slipped, sustained injury, and brought the claim. Now, the first issue in relation to this was an expert issue. There were two experts who each gave evidence. And what the defendant said in that is an interesting argument, was essentially the Bolam test. So what the defendant was saying is, if you have two expert views and they are both credible and they are both reasonable, then it is not for the court simply to choose one of those views. The court has to go through the exercise of determining that the expert view that is going to be rejected is in some way irrational or untenable or in some way ought to be rejected. Now, those of you that have or do clinical negligence work, we're very familiar with the way the Bolam test operates in terms of standards, and also what was called the Belitho prism, which essentially is where you have two conflicting experts giving views. If the court is not satisfied that one of those views is irrational and can't withstand logical scrutiny, then necessarily the claimant's going to struggle to establish liability, because you've necessarily got two views, both of which are credible. And in this case, it was argued, and in fact, the judge at first instance accepted that this was a similar situation. If you had a credible view from two alternative experts, then the claimant wouldn't be able to satisfy that there was a breach of standards. Now that then in this particular case became less important because in fact the defendant's expert had looked at things erroneously, and the view that was put forward by the defendant, which is that it could be type 1 tiles, was rejected. So in this particular case it wasn't of significance, but it may indicate the way that these cases are likely to evolve in future if you've got a situation where you've got two conflicting expert views. What was also important in this case is the fact that the claimant's expert had not measured the actual slip resistance of these tiles. So a type 1 tile can have a slip resistance of between 15 up to 35. A type 2 tile has a slip resistance of 35 to 50. So there is, although there's not a strict overlap, the reality is that a poor type 1 tile, sorry, a good type 1 tile can be broadly similar to a poor type 2 tile. And what the expert said is that a difference of 1 or 2 in terms of the numeric assessment that they use would be of no causative significance. So what was said is that unless the claimant can prove what the slip resistance was of the tiles that she fell over, then you can't prove that there was a difference between type 1 and type 2 tiles that caused the accident. And again, the judge found for the defendant on that particular issue, and that was the reason that the claim was dismissed. It was appealed then to the county court judge. I think it was a district judge decision. It appealed to a county court judge sitting as I think a section 9 judge, and that appeal was dismissed on the basis that the findings of the judge were entirely reasonable, and there was no reason to interfere with them. Now I'm very, very conscious of time, that I'm taking up a little bit too much. I'm going to leave Kellett. Kellett's a case, an Irish case, where it was an accident on a speedboat excursion, where you'll see from the slides what happened is that the engineer was not able to point to any breach of local standards as to the reason. The engineer was critical of the safety standards applied on the boat trip, but wasn't able to point to any breach of local standards, and that was sufficient for the court to reject the claim and say that it wasn't made out. Although then the judge went on to determine that even applying Irish standards, there would be no breach either. So it was determined in the appeal court referred to it as being stress test against the relevant Irish standards, although the standards are of course local. But I'll leave that. The slides set out a little bit about the background to it. Griffiths, then, you might well be familiar because it's a slightly different case, but it's very, very important in terms of local standards as well. Griffiths is the case that deals with whether the court can reject an expert's view. And what had happened in Griffiths is it was a gastric case, and again, tend to be very, very common, these gastric cases, and they tend to be relatively low value. The claimant had evidence to suggest that on the balance of probability, it was likely that the gastric illness that the claimant suffered from was a result of contaminated food or fluid from the hotel, which obviously establishes a breach of the implied duty to provide proper food and the like. Questions were then put by the defendant to the expert, but the defendant chose not to obtain its own expert evidence. But at trial then, the defendant submitted that there were various reasons why the report of the expert could be rejected, and essentially the judge shouldn't go with the conclusions in the report. That was successful at first instance. The judge was critical of the report and rejected the report and found for the defendant. That was then appealed to the High Court judge, who took a different view, who took the view that essentially this was an uncontroverted expert's report because it hadn't been challenged in cross-examination, because there was no corresponding evidence from the defendant, and that in those circumstances it should go through, and it wasn't open to the defendant to challenge it at trial. Court of Appeal then rejected that decision of the High Court judge and essentially went back to the first instance decision. It determined that the report wasn't binding on the court, that essentially was a matter for the judge. If there were reasons why the judge was satisfied that it could be rejected, then that was entirely a proper way for the judge to approach it. Essentially, it looked at a number of cases in the past that dealt with the way that the court should look at expert evidence, and said that there was nothing that indicated that the court had to be bound by expert evidence simply because it was expert evidence. The court is entitled to take its own view. There was an absolutely scathing judgment by Lord Justice Bean, which was a dissenting judgment, which really is worth reading for the way that he deals with what the defendant had done in terms of putting questions and not calling their own evidence, and the way that the court should approach that. Whether that case goes to the Supreme Court, again, when I first delivered this talk a couple of months ago, my understanding was that it would go to the Supreme Court, but we've yet to hear anything more about that. And as frequently the case, often these things are compromised for tactical reasons. But it would be good to have the Supreme Court look at that, because it's of massive significance to expert evidence generally, and of particular significance to holiday cases in terms of local standards, and also in terms, obviously, of gastric cases. Now, just dealing finally with Morgan, and aware that I'm sort of trespassing now into Freddie's time, the issue in Morgan was the claimant fell over as a result of tripping on a sunbed in Mauritius. And the evidence was that there were no, it was an accident that happened at night, and the claimant's case was that the lighting was inadequate. Now, the evidence was that there were no local standards of lighting applicable in Mauritius. But what the judge did at first instance is to use an international standard, which was not binding, to determine what he thought was the appropriate standard. It should be the appropriate standard under the contract, notwithstanding the absence of specific evidence in relation to, or specific standards in Mauritius. So to some extent, it's a slight rolling back of Lougheed. All of these cases are factual, and they're all very much subject to argument. But if you read the slide, and I won't do that for time reasons, you can see that essentially the international standards provided for a 0.5 lux standard. The light in this particular case was half of that. It was 0.24. The judge found that that breach of international standards was sufficient to establish liability. The tour operator argued that that wasn't binding on, wasn't binding in Mauritius, and there was no evidence of local standards in Mauritius, or no standards in Mauritius, and therefore the case should be dismissed. And the High Court went through that, and essentially you can see from the slide that's up now, I won't go through each of the bullet points, but it demonstrates the approach that was taken. And it essentially says this, to summarize, that local standards are very, very important in these type of claims, but they are not necessarily definitive. And there may be some circumstances where the local standards are overborne by other factors. So it just seemed that it's a slight rolling back from Lougheed on the basis that these are essentially domestic cases. So you are suing in this country, applying English law. It is the standards then that are international or assessed in the foreign setting, but that might not be definitive depending on the particular circumstances. As I said, in this particular case, the judge was not wrong to determine that an international standard, which had double the standard of double the light, was something that the judge could take into account in being satisfied that the holiday company was a breach of duty. Okay, sorry, Freddie, if I've taken too long. Over to you.
No, not at all. Follow that.
Do you want me to stop share?
If you stop share, and I'll start. Right, hopefully that's all come through for everyone. Yes, I mean, what a lot of ground that's been covered. There's quite a lot more to go, I'm afraid. In terms of jurisdiction, I will, as I say, said before, I'll take this as quickly as I possibly can. In terms of the context, there's been an awful lot that's happened in jurisdiction. We've had Brexit, obviously, which has removed the rights generally in relation to jurisdiction confirmed by Brussels recast for European countries. Now, while that didn't change the position for rest of the world cases, it did make the EU member states effectively rest of the world countries for the purposes of jurisdiction. In that context, we then have the decision in Brownlee, which now will be applied to all of the EU member state cases, because Brownlee was a rest of the world case involving an accident in Egypt, and it takes on even more relevance in that context, given that most regularly, I suspect, we see EU membership cases across our desks. I know I certainly do. So with that as context, I'll see if I can attempt to change slide. Here we go. So just again, briefly, there will be cases that you're seeing still that are under the old rules. In some cases, those will be cases that were instituted pre the withdrawal agreement. There are probably not a huge number of those left, and certainly not very many where jurisdiction could be challenged, if any. It is important to bear in mind, in addition, the derogations. There have been a couple of savings from the Brussels recast agreement. Consumer contracts, although that doesn't apply to contracts for transport, or at least not transport alone, without accommodation in addition, and also contracts for employment. Now, it's important to remember that these derogations exist when we're considering jurisdiction, because if you've got, for example, say a cosmetic surgery case from, let's say, a dental treatment carried out in Turkey, if that treatment was advertised in the UK, the contract entered into in the UK, you will still be able to use this potentially automatically without having to go through the difficulty of serving out with permission of the court, which we'll come on to. Likewise, for example, if you've got a claimant who's an employee who's working abroad, again, you may find that you are able to simply use the Civil Jurisdiction and Judgments Act 1982 rather than going through all of the rigmarole of applying for permission. In terms of service, that's the first thing that claimants will need to be thinking about. How to serve. My advice, if possible, serve within the jurisdiction. It's then only a question of whether jurisdiction is going to be contended for by the defendant. The defendant will then, under a Part 11 application, have a much higher hurdle, the hurdle of it being clearly the appropriate forum being overseas. Of course, if you serve out, then for claimant, you have got the forum convenience test, and again, we'll come on to that. Those are the situations in which it's going to be easy enough to serve in this country. So where somebody who is temporarily in the jurisdiction, or if more likely they've nominated a solicitor for service or provided a business address for service, it doesn't prevent a challenge to jurisdiction under Part 11, but it does make it much harder. And as I say, the defendant has a higher burden and bears the burden of proof in relation to that. There are some instances with gateway by right. These are set out in CPR Rule 6.33. I'm not going to go into any kind of detailed analysis of it, but consumer claims, we've already mentioned those, claims under the 2005 Hague Convention, and then the sort of anchor defendant claims, which again, we'll deal with in a little bit more detail. In terms of the Hague Convention, I'm going to deal with this exceptionally briefly, because if you're dealing with PI, as myself and Andrew mainly are, you're very rarely going to be in a situation where a Hague Convention situation is going to arise. It only applies in relation to where there's a contract which has been breached with an exclusive jurisdiction clause. That contract has to be concluded after the entry into the convention. There's also going to be a gap here because there's differing views between the UK and the EU member states about retrospection. The UK has joined the Hague Convention in its own right, but it originally joined as a member of the EU. So there is a question over whether it dates back to 2015 or whether in fact it is post-dating Brexit, and that is yet to be resolved. But as I say, it's very unlikely to be relevant because consumer contracts are excluded, can't be applied to PI, even if it's based on a contract, and it doesn't apply to contracts for the carriage of passengers and goods. So it's incredibly rare that it's going to come up, but it's still probably worth knowing about, particularly as it's referred to within the rules. In terms of the special liability regimes, these are again a point where you don't need to consider jurisdiction. So in some ways, this is all still context. Under Athens, if the accident's at sea, the jurisdiction's under Article 17. It's very wide. If you are seeing a case under either Athens or Montreal, the chances are that there is going to be jurisdiction established. It's going to be relatively straightforward because there are so many situations in which jurisdiction is granted under those conventions, and very few which would involve a claimant ever considering instructing an English lawyer. I think there is a brief update here, which is important to note in relation to choice of law in these cases arising out of the conventions. It used to be thought that these conventions were very much their own thing as a cause of action, that as a result that Rome II didn't really apply in terms of choice of law, and they were simply decided by the law of the destination, and that was the standard route. But that was turned on its head somewhat in 2021 by a judgment of Master MacLeod. That's in the case of Silverman and Ryanair. In that case, the judge found that the principles for determining applicable law were tortious principles. They weren't based on the contract of carriage. They were based entirely on tort because of the convention being its own thing, but still being a tort of sorts. As a result, under Rome II, it's therefore important to consider things like where the damage was suffered for purposes of consideration of the choice of law. And it is worth bearing that in mind. I know it doesn't have a relevance particularly to jurisdiction, but still very important. So let's imagine you've gone through that. You haven't got any special liability regimes. You can't serve in this jurisdiction. You're going to need to serve out. In that situation, you've got to make an application to serve out of jurisdiction. The claimant has to establish in that application that they have a good arguable case that one of the jurisdictional gateways in practice direction 6b applies, that the claim itself has a real prospect of success, and that finally England is the proper place, or England and Wales, I should say, the proper place in which to bring the claim. Dealing with the first hurdle, the good arguable case test. What Lord Sumption and Baroness Hale have essentially described in Brownlee, and this has been updated somewhat in 2017, is that it means what it says. For a long time, from 1998, we applied what's called the Canada Gloss test. That was that, as set out there, that a good arguable case reflected that one side had a much better argument. That has now been largely moved away from. You can see in Lord Sumption's judgment there, that right at the bottom, doesn't believe that anything is gained by the word much, which suggests a superior standard conviction. So in that sense, the crucial thing is that the claimant can plausibly explain why one of the gateways applies, and it might be necessary to produce some evidence supporting the factual version of events that allows for the claimant's argument to be accepted. And if there's a factual dispute about those events, in clear cases, it may be possible to deal with that at the interlocutory hearing. But in many cases, the claimant, if they have a plausible case on their own facts, is to be given the benefits of the doubt, and the good arguable case test will then be passed in those instances. So that moves us on to the second hurdle, dealing with the first hurdle. We're still on the first hurdle, dealing with which gateway is going to apply. For the personal injury cases, the relevant gateways are likely to be these ones. So where there's already a claim against the defendant which has or will be served in England and Wales, and the proposed defendant is out of jurisdiction, is a necessary or proper party to the claim, or where a claim is made in reliance on the paragraph below, which we'll come to, and a further claim is made against the same defendant arising out of the same or closely connected facts, Now, these are known as the anchor defendant principles, the anchor defendant gateways. Defendants often feel pretty aggrieved at being pulled into jurisdiction by these. There is an important update on these, which arises out of the cases ID and LU and another from 2021. In that case, the anchor defendant was brought in on the basis that one of the defendants had submitted to the jurisdiction. So there was no other gateway that applied. It was only that there'd been a submission to the jurisdiction. And it's been confirmed by His Honour Judge Pelling, QC, that in fact that is not enough. It needs to be more than that. There needs to be a reason why the other defendant was actually brought within the gateway rather than just a submission to jurisdiction. So if you've got one of those cases, it's something to be aware of. In contracts, it's where the contract was made in the jurisdiction, where the contract was entered into through an agent trading or residing within the jurisdiction, or where the contract specifies that it will be governed by the law of England and Wales, and or where the breach of contract occurred within the jurisdiction. Again, in 2017 in Brownlee 1, both Baroness Hale and Lord Sumption made obiter comments expressing their dissatisfaction with this rule in cases where contracts were made by instantaneous communication. So if you imagine a situation where you've got a holiday situation where you're making the contract overseas, let's say you're dealing with a company based in Egypt, you're sending back and forth communications. There's then a question over where is the contract formed. You're both based in your respective countries. It would involve quite a detailed analysis of offer and acceptance, which really isn't suitable for consumer contracts particularly. That comment and those comments generally have been cited relatively recently with approval in the High Court in Ditto Limited and Drive-Through Records. It's suggested in that case that it might be arguable that a contract was made within both jurisdictions simultaneously. It's certainly an interesting concept, and it does mean that if you're at the permission stage and looking for a good arguable case, if you've got an instantaneous contract negotiation via that communication, that will be a very helpful case to establish that you have a good arguable case, even if it's not a fact, if it's not established on the facts. In tort, and this was really the big change from Brownlee 2, where damage was sustained or will be sustained within the jurisdiction, or where the damage results from an act committed within the jurisdiction. So that was discussed substantively in Brownlee. Damage for the purposes of the gateway extends to indirect damage. So, and to damage and financial consequences sustained by a claimant's estate and dependents. So let's say, for example, again, you have a situation with a catastrophic accident. Claimant is receiving care in the UK, having been repatriated. In that situation, they will be suffering the damage or continuing to suffer the damage within this jurisdiction for the purposes of the tort gateway. It doesn't matter that the incident arose out of a skiing accident in France specifically, for example, or although again, it will be a consideration when you consider the forum conveniens test. There's no suggestion, I should say, of a de minimis exception within the judgment. The judgment simply suggests that that is how it's assessed. So if you can establish any amount of damage sustained within the jurisdiction, then it is likely you'll fall within that tort gateway. That point is yet to be tested, but it will be interesting to see when that arises. It does create a disconnect between the definition of damage for the purposes of establishing jurisdiction and damage for the establishment of applicable law. So the Lazar case, which is the case from 2015 in the European Court, that established that damage for the purposes of applicable law is the damage where the act took place, so the direct damage. The indirect damage does not feature. So there is now two different tests, and the Supreme Court have considered that and concluded that it wasn't a sufficient concern. In terms of the second hurdle, this is whether you have a good case, a real prospect of success. Now, we're all familiar with the real prospect test, but it's important to remember that when you're dealing with a foreign law case, a case where the applicable law might be the law of a foreign jurisdiction, it is whether you have a real prospect of success under the law of that jurisdiction. And that's extremely important in terms of the way you put your case for the application. You may need, possibly, proof of foreign law. And I say possibly because this was considered in some detail in Brownlee 2. Previously, the default rule and the presumption of similarity were often equated. And just so that I've explained it, the default rule allows a party to essentially call no evidence as to foreign law at all. And not just evidence as to foreign law, not even to rely on foreign law. And it's only if the defendant challenges it and says, hang on, Rome 2 applies here, foreign law applies, and you need to prove it, does the court begin to then assess the case under principles in the Rome Convention, under generally English private international law. So it's only in those cases. The presumption of similarity is where it's accepted that foreign law applies, but neither side adduce any evidence as to what the foreign law is. In that situation, then it will be assumed that English law and foreign law are substantively the same, as long as that presumption is a reasonable one, and in the absence of evidence to the contrary. It might be, for example, an unreasonable assumption to assume that French law under a civil code would be the same as English law, but other jurisdictions, for example, Canada, it might be a very safe presumption to assume they're the same. So that's what the court's talking about there. And it will be, there will only be certain cases where you will want to take that risk, I would have thought. It must be remembered, of course, it is also possible to agree. But in terms of the English law is the same. It's something that we need to be aware of, because if you're applying to say, I've got a good arguable case or a real prospect of success on my case, then it will be necessary to either show that the foreign law issue hasn't arisen and therefore the default rule applies, or to show that it has arisen, but that neither side has advanced evidence of the foreign law to suggest that you're wrong if you're for the claimant, or indeed that they have advanced evidence and it does show they're wrong if you're for the defendant. So that's something that you need to be considering when dealing with these applications. Even where it must be proved, there are situations where a judge can take some judicial notice. Open sources of law, it doesn't need to necessarily be by expert evidence, can be sufficient proof, but again is somewhat risky. Even more risky is what happened in Soriani and Forensic News, where essentially it was the chance was taken that the judge would be familiar with that law, and it happened that they were. And the judge applied their knowledge of the foreign law to that case, and that decision was upheld by the Court of Appeal. As I say, the aspects were described as well known. I don't think they were that well known, but the Court of Appeal upheld the judge's decision nonetheless. It's something that would be quite a risky strategy, I think. So the boundaries remain unclear. And again, there will be certain situations where it's going to be prudent to get expert evidence at the earliest possible instance. In terms of the third hurdle, I'm going to deal with this very briefly because forum convenience is absolutely enormous. Books are written on the subject. But as a broad brush, the court's got to be satisfied that England and Wales is the most convenient forum for the claim to be heard. Now, that's sort of two parts. There's a first part where the court will assess whether or not essentially it's clearly the appropriate forum. And then a second part where the court will assess whether in the interests of justice overall, it's still appropriate for the court to either accept jurisdiction or grant a stay while the claim is dealt with in the foreign jurisdiction. And that is a more nuanced test dealing with the issues of whether the law of the forum, which applies to procedure, can offer a claimant or a defendant a better route to a just outcome. And that's, again, putting it very broadly. There are going to be myriad circumstances that apply. The Spiliada Maritime Corporation case is always going to be your starting point. The factors that are relevant are going to include whether the applicable law and the law of the forum are the same. That obviously matters. Location of witnesses, the language of proceedings, the location where the damage was sustained, personal factors related to the ability of the witnesses to travel, jurisdiction where other related claims have been dealt with, where there's any jurisdictional agreements between the parties, and the availability and ease of enforcement. All of those are going to be relevant and more, that you're going to have to assess each case on a case by case. So let's imagine that either the claimant has then gone all the way through this, they've managed to get permission to serve out, jurisdiction is prima facie established, or alternatively, they served in the UK and you're a defendant and you want to challenge jurisdiction. If that's the case, the defendant should make an application under Part 11 to challenge jurisdiction. They should also, on the acknowledgement of service, tick the box saying they're challenging jurisdiction. They should do absolutely nothing else if they can avoid it, because by doing something else, there is a serious risk that you can end up submitting to the jurisdiction, and we'll deal with that on the next slide. I deal there with some of the practicalities. It's got to be supported by evidence, and the burden is going to be on the defendant to show that their foreign jurisdiction is clearly the appropriate forum. Now that's important, because in some cases certainly that's regarded as a higher test than just on balance. Cleafer is a recent case which has demonstrated this all too readily, I'm afraid, for the defendant in that case. That claim arose out of a skiing accident in France. The defendant was served in this jurisdiction, but sought to challenge the claim on forum convenience grounds. A great number of factors were put before Master Dagnall before they gave their decision that were all weighed up and considered. And the court found that the question in relation to the clarity of where the appropriate forum was that had that question been an open one, he would have found that France was the more appropriate forum on balance, but it was not clearly the more appropriate forum in all the circumstances of the case. Perhaps of more interest is that the conclusion on the second limb of the test in relation to the interests of justice, that the judge in that case had noted that the defendant had allowed the claimant to proceed through the pre-action protocol during the transition period pre-Brexit, when there would have been an absolute right to bring the claim within the jurisdiction under Brussels recast. And it was only after exit day that the defendant sought to challenge jurisdiction. And I should say, obviously, it wasn't issued pre-Brexit, but it was only after exit day that the jurisdiction was sought to be challenged. That was likely to lead to significant costs of the pre-action protocol procedure being thrown away by the claimants, as those wouldn't be reclaimable in France. It didn't amount to the defendant's actions didn't amount to a submission of the jurisdiction, but it was enough to tip the balance in a dispute on forum convenience. And the judge found that that had seemed to be a tactical decision, and the interests of justice again pointed in the direction of England and Wales, where the pre-action protocols had been complied with during a period where issuing in this jurisdiction would have led to an automatic grant of jurisdiction, was a relevant feature for the purposes of the forum convenience test. So that brings me to two warnings for defendants. firstly, submission to the jurisdiction. In principle, one should be extremely wary about doing anything other than applying to challenge jurisdiction in the case where that's what you want to do. You can apply for a stay of proceedings without consenting to jurisdiction, and you'll see that from the Williams and Glinsbank case. More recently, in the PGS Bank Finance and Credit case, a conjoined application for strikeout and summary judgment together with an application disputing jurisdiction was found to not be enough to be submission to the jurisdiction. But of course, as I say, the fact the case exists shows that it was challenged. Even more risky, and by now we're really looking at very risky behavior by defendants, Zumax Nigeria, and more recently as well. The defendant in that case had been crystal clear throughout in all their correspondence that jurisdiction was an issue. It was a case in which they believed they had a very, very good case on strikeout. And what they did is they made that application for strikeout and combined it with an application for a declaration that jurisdiction was not conceded. And in that particular case, it was appropriate because the strikeout application was strong, but the jurisdiction application was incredibly complex and would have wasted an enormous amounts of money and court time. That was a very risky strategy. It's not something I would generally recommend, but it is worth knowing that it is possible. But overall, you've got to beware over-challenging. Make sure that you target the appropriate areas, and that was the lesson from the very recent case of the Abu Dhabi Commercial Bank. In that case, the defendant put all three of the limbs of the jurisdiction questioning in issue, and we've obviously discussed them. They were successful in getting jurisdiction moved to Abu Dhabi on the basis of the forum conveniens argument, but their arguments on the first two limbs were very weak, and they lost both of them. And rather than saying, you've won jurisdiction as a whole, here, have all your costs, the judge in that case said, no, these are three separate issues. I'm making an issue-based costs order. You get a third. So it's certainly something to bear in mind when making these applications, that rather than throwing the kitchen sink at these things, they are treated separately. And because they're complex, because they take time, it is worth considering very carefully how you want your applications to be targeted before making them. Otherwise, you face costs orders such as this. And I think I have managed to keep the time. How about that? That's everything. Andrew, it strikes me that there was quite an overlap in one respect in our talks, which is that there seems to be a big separation between this idea that default rule and the presumption of similarity applies when you're dealing with foreign law. And yet the courts have been, right up until Morgan, so strict on local standards evidence, saying you've got to have something before it, we can't presume anything. I don't know what you think about that, but it certainly seems like quite a split between the two.
Yeah, I agree with that. I mean, what's interesting about Morgan is a High Court decision, but it goes back to this confusing interplay, really, as to where we are, and it talks about the contractual claim as being a domestic claim, and whereas in some ways, much as it hurt me at the time, Lougheed is at least clean, because it said unless you prove a breach of local standards, you can't go anywhere. Whereas Morgan throws it back to, well, it might not be determinative and everything else. So yeah, I think there's more legs in it, I think.
So as far as I can see, amazingly, we've been so consistent that nobody has any questions, as far as I can see. But as you see, our emails will come through on the slides. If there's anything at all that occurs to anyone, then please don't hesitate to get in touch with either of us or both. We're very happy to answer any questions you may have. But for now, I'd say thank you very much. That's our talk.
Thank you.